Everyone. My name is Chris Lewis. I'm the VP of Legal Operations at Super Legal. We're a legal tech company that uses expert attorneys and artificial intelligence technology to review and redline, negotiate commercial contracts, among other things. It's a pleasure to join you today. I'm looking forward to answering some common questions in the commercial contracts arena. I'm an attorney of 25 years experience in real estate, construction, commercial contracts, and litigation. So it's my pleasure to answer some common questions that we see in commercial contracts, to address some of the legal risks we see. And so I'll dive right in. I think as a preliminary thought, I'd like to talk a little bit about contract law, because we're going to be discussing navigating legal contracts. And one thing to keep in mind is that contract law is about private law. We have statutes, laws adopted by legislative bodies throughout the world, and those are public law, and courts enforce those laws. Contracts are enforceable as private law between parties. So courts will actually enforce the agreements of parties just as though they were public matters of public law. And what I think is relevant there is, as a general rule, any contract, any agreement between parties can be enforceable by a court of law as though it were adopted and imposed by a legislative body. So when we talk about contracts, it's good to tuck that in the back of the mind, is to think of the significance of being in a regime where private agreements between private parties can be enforced by courts of law and have significant legal implications for the parties involved. So as we discuss this, I might refer back to that principle. One of the big questions we get, that attorneys get involving commercial contracts, is the allocation of risk, of liability. So what should I look for in liability undertakings in a contract, and why is it important? So that's the first question I'll address. The allocation of risk is a significant part of what parties are addressing in a contract. They may be addressing the scope of work, what exactly each party's obligations are with respect to a particular service or the supply of a product. But what is critical behind merely that scope of work is the legal liabilities that are being incurred by the parties. So two main provisions in the contract really are implicated when we're talking about allocation of fault. One is indemnification clause, and the other is a limitation of liability clause. So I'm going to talk about both of those and how it affects the allocation of fault between the parties. Indemnification is very simply the idea that one party is responsible for certain events that it normally wouldn't be responsible for. So I'll be more specific in a moment, but generally, if something happens, let's say that you live in a far-flung place, far from me, I've never met you, I've never been to your home, and let's say damage happens to your home, you would have no claim on me for paying for that damage. An indemnification clause is a way of assigning responsibility to someone that they wouldn't otherwise have outside of the contract. So it is an undertaking of responsibility for an event that otherwise a party wouldn't be responsible for. So if, for example, you hire me to paint your house, and I come and paint your house, and I use toxic paint and the neighbor's dog dies, if I indemnify you against claims from the neighbor for the death of the dog, then I've undertaken an indemnification obligation. I might have to reimburse you. I might actually have to jump into the lawsuit and defend the claim against you. But I would take on full responsibility for the harm to that dog if there was an indemnification clause that required me. I hope that's not too gruesome of an example. But when we talk about indemnification, we talk about undertaking those types of responsibilities that might be related to the service we're providing, in this case, painting your house, or we might not. So the parties can negotiate that and can determine between them what types of responsibility a party is willing to undertake on the one side, and that the other party, that usually the customer, the buyer, the purchaser, wants on the other side. So those are heavily negotiated and are critical parts of a contract. So if I'm representing the purchaser of a service or a product, I would advise my client to have broad indemnification obligations imposed on the other party. I would request a significant amount of coverage for possible liabilities. In fact, I might say any liabilities arising from my services, which is a very broad indemnification obligation. If I'm representing the service provider, on the other hand, or the product supplier, then I would want to limit that and keep it as narrow as possible. I'd be willing to maybe offer some indemnification, but maybe not every indemnification. So let me give an example. Let's say that you've hired me to paint your house because you want to have a wedding reception in the backyard and you want the house to look really nice. And so I come in, you've hired me to paint it. I painted the wrong color. Immediately I'm liable, right? Because if you specified a color, I didn't meet that obligation, you've got a liability issue. I would be liable for getting it right. But if we have an indemnification clause and I'm indemnifying against that harm to the neighbor's pet, or indemnifying against the photographer's claim that I finished it late and therefore he lost or she lost profits or lost to the job because of my delays, we're talking about possible indemnification, areas of indemnification. So those need to be heavily looked at and heavily scrutinized. So why are they important? They are important to limit and allocate the risk between the parties. I mentioned the other is limitation of liability clauses, and so I will address that briefly as well. In that same hypothetical, painting the house for a wedding, there are a few ways of limiting liabilities of the party. One is just to put a cap on the total liability. So you could say, hey, paint my house for $20,000. If for whatever reason you fail to do that, we get to sue you. And I come in as the service provider and I say, okay, but we need to cap that liability. It can't be unlimited. It needs to be capped at a certain amount, say $30,000 is my max liability, or it can be tied to a dollar amount. It can be tied to the contract value. It can be tied to anything, a multiplier of the total value of services provided. And that's a way of ensuring that my liability isn't unlimited, isn't infinite. Another type of limitation of liability clause is to limit liability to direct damages, not consequential or indirect damages, ones that are incidental to what I do. So, for example, an extreme example of an indirect damage would be that I'm delayed in painting, it interrupts the reception, and it causes marital problems and divorce of the couple being married. That's very incidental to what I did. It's indirect. It's not directly related to the painting I did. But if there were some liability claimed that my tardiness ruined a marriage, a limitation of liability clause that limits to direct damages only would prevent that. More common is that the limitation of liability would be tied to the I just lost my train of thought because I just saw a question. So I'm being asked if that's a true story. No, that is fortunately entirely hypothetical. But it illustrates some of the concerns that we have when doing things is a more realistic, this is what I was about to say, is a more realistic form of indirect damages would be lost profits. So you provide a service for a company and it claims your failure to provide the services as promised caused me to lose a lot of value. I wanted you to design my website. I want to launch on May 1st. You failed to do that, and I lost $10 million in the first week. Those can be highly speculative. They might not be highly speculative, but in any case, a limitation of liability clause on limiting to direct damages only can prevent some of those types of claims. So those are important. Those are heavily negotiated. Those are probably why contracts get delayed sometimes, is trying to work out those issues. But you can see how it ties back to what I was saying before about allocation of risk. We are talking about taking risk. Both parties are incurring some risk, and how do we allocate between the two parties? So if you're having me paint your house, the risk you're taking is that I'm going to do a good job, get it done on time, make it look nice, that it's not going to cause problems, that I'm not going to break windows, that I'm not going to drip paint all over the ground or get bugs stuck in the paint. Those are all important to the homeowner. And on the flip side, my risk are some of the things we discussed as the service provider, that I might be responsible for things I can't control. So the allocation of risk usually comes back to who is controlling what, who is responsible for what types of risks, and who's really in control. So we like to bring it down to control issues. I welcome any more questions, but those are the general principles when we're looking at controlling liability issues in a contract negotiation. Indemnification, limitation of liability. There's much that can be discussed on that. That's more an introduction. Those are general principles only. The next question I have is, how do I protect my intellectual property? I think the first question there is, do you have intellectual property to protect? If I'm painting your house, there may not be much in the way of intellectual property that's involved. But if I am designing a paint job, if I have workers who are helping execute on it, there could be trade secrets involved. There could be design issues. The design that I show you might be my intellectual property. So it becomes an issue in a lot of contracts. And intellectual property can be addressed in a number of ways. One, before discussing a project, a potential relationship between a purchaser and a service, or a purchaser and a product supply, the parties may enter into an NDA if they feel that confidential information, including trade secrets, could be exchanged, and trade secrets are considered intellectual property. Trade secrets can be processes or operations or ideas related to that are unique to your business, that relate to how you perform. And that's intellectual property that an NDA can protect. So having a good non-disclosure agreement in place can protect the use and disclosure of intellectual property, primarily the disclosure. So in an NDA, one party or perhaps both parties are asking the other party to not disclose certain information to other folks. So I may say, I'm willing to show you the design for this house, but you're not allowed to share it with anybody else, except maybe your employees, and you can define that in the non-disclosure agreement in the NDA. But it's a way of controlling who you, as the recipient of my confidential information, which can include intellectual property, who you may share it with. But generally, an NDA is not the place where intellectual property rights are heavily addressed. More often, it's in a contract that comes later, as the relationship between the parties is reduced to an ultimate contract. And that will have often an intellectual property section in it. That may say, for example, that each party retains its own intellectual property that it had prior to entering into the contract, prior to the relationship between the parties, but may also grant some interest in the other party's intellectual property for a particular purpose. So, for example, I may design how I paint your house, and it's a very complex design, one that you asked me to do as an artist and a painter. And I design that, I show you your house and where it's going to be painted, the different colors, the different tones, the different, artistic elements of my paint job. And I may say, look, when you pay me, that's yours. That plan is yours. Or I may license that intellectual property to you for a specific use, for a limited use. I may give it to you entirely. I may license it, but in some way you're gathering some interest in my intellectual property. And when we talk about that interest, it's often analogized to a bundle of sticks. So picture you have a bundle of sticks, and that total bundle of sticks, perhaps it's tied off in a bundle, that represents all of somebody's property interests. So if you're talking about intellectual property, it's the total interest I have in, it may involve copyright, it may involve patents and trade secrets and other things, and they're all bundled up together. And that's the totality of my interest in my intellectual property. But I may grant you the whole bundle, complete ownership rights, with me relinquishing all ownership rights. Or I could retain my ownership rights and give you one or two sticks out of it. I could give you a portion of my intellectual property. So when we talk about intellectual property rights, we often want to carefully think, both as the customer and the service provider, or the product supplier, or the manufacturer, or whoever you are, what you want to give to the other party and under what terms. Do you want to give full ownership? Is it only after full payment? Is it conditional on other events, on the other party fully performing in other ways? Is it the full bundle of sticks or just a few sticks? Is it a licensing arrangement? So those are ways that you can protect your intellectual property. To recap, through an NDA, can have some limited benefit in protecting intellectual property, but a more formal agreement is usually required to protect a party's intellectual property. So that's a great question. Again, that's just an introduction to the subject. There's a lot that can be said on it, but the next question I have is, what should I be aware of when reviewing contracts not on my own template? So that's a great question, and that's a significant question. So often a company that provides services will have their own contract that they prefer to enter into. So they may have a form, you fill in the name, the address of the parties. I'm going to paint your house. Here's the price. Here's the cost. Here's what's included in my services, what's not. The parties sign it. Great. It's in your template. If the party signs it without negotiation, you're very confident in what your rights and responsibilities are. However, often somebody will say, nope, we're not using your template. We're not using your contract form. We're using ours. So the question here is, what should be aware of when reviewing contracts from the other party? The first thing you want to do is read it and make sure you understand it. That sounds simple, but I have had, this is a true story. I had a client call me up and say, I purchased a house and I'd like to get out of the contract, possibly. Can you review the contract? I said, well, wait a second. You already purchased it. What utility am I at this stage? You've already made the purchase. And they said, yeah, we've already signed the papers, already made the full purchase, but we still want you to look at the contract. I said, fine, I'll look at it and give you my 2 cents. So they emailed it to me. We're on the phone for this consultation. Is a long-standing client of mine. And I read through it and gave a few quick thoughts. And they said, how can I get out of this contract? We don't want to be in this contract anymore. I said, first of all, it looks like a pretty solid contract and you knew what you were getting into, so I don't think you should attempt to get out. So my first advice is to honor the contract by staying in it. But I did give some interpretation to them. And then I advised them, in the future, please reach out to your counsel prior to signing an agreement. So one thing you could be aware of in signing an agreement is understanding it. That may involve simply reading it or conferring with an attorney or conferring with another trusted advisor, but it's good to understand what you're entering into. By the way, as a footnote to that story, they were trying to get out of the purchase of this investment home. I refused to break what I saw as a proper contract. And a year later, they let me know that the house had almost doubled in value, and they're glad they never got rid of it. So sometimes a contract can protect us against ourselves. So there's probably a word to the wise there. But in looking at a contract that's not on your template, not on your form, I would look at some of the provisions we already discussed. Intellectual property. Is there an exchange of ideas, of IP that is going to go to one of the parties from the other? I would look at indemnification and limitation of liability. And I'd look at related things that are important to your industry. For example, in the construction world, we can often see how it'll say that if there's a delay, you're responsible for delays. And if you cause a delay, you, the service provider, are liable for those delays. And we like to say, well, hang on a second. What if those delays are caused by you? So different industries may have different considerations about what's important to look for in a contract. And nobody knows that better than you, the business owner. You, the contracting party. You know what you need best. Sometimes you have to navigate that with experts. So if you're an owner of a home or a property and you want a house designed and built, you may not be an expert in design and building, and you may need to confer with an architect or an engineer or with an outside contractor, builder, to be able to navigate that complex relationship and the complex responsibilities and liabilities that come with building a large building. So those are significant terms that you want to look at when getting into a commercial contract. I see another comment here. I usually get contracts from a third party, and I am not always sure what to look out for and if my interests are protected. What do you suggest I do? So when you're really unsure, you really should go to an expert if possible. And anytime you're talking with private law, which, as I mentioned at the beginning, a contract is, remember, this is a legally enforceable contract that, even though it discusses the private interests of private parties, it is legally binding. And so getting legal advice is important. There are lots of legal services out there. For example, Super Legal, our company, routinely redlines contracts to try to negotiate through the other party's template, the other party's form. And it can, by the way, be sometimes almost absurd. We had a situation where a client received they wanted to offer pest control services. That was what their business was. And the counterparty that was hiring them was a tech company and said, we don't want to use your form. We're going to use our form, and then supplied a SaaS agreement, which is software as a service agreement, which is designed basically most commonly when you're using an online portal of some sort and you're using a service that you log into. In other words, totally inappropriate and inapplicable to the provision of pest control services. So that can be really strange because you find that template that they provided, that contract form that they provided, is totally inadequate and does not address the things you need to address, and addresses all sorts of things like downtime for a website that are totally inappropriate for pest control services, such as personal data and user rights and obligations. And so, needless to say, we had a heavily redlined contract we had to return. But that's what a service like Superlegal can do. You can also hire private counsel, and they can do red lines and help you negotiate the contract. So I hope that answered that question. Moving along, well, just to recap, if you're reviewing a contract not on your own template, I would say number one, read it. Number two, make sure you understand it, which may involve conferring with experts. And three, if you lack confidence, it's probably time to get legal counsel involved to either do a total red line, a total negotiation, or at least to advise you before you go too far into that. We have experts in this world. Very few people know everything about everything. Most of us are very focused. For example, I cannot install solar panels on my roof. And if I did that, my wife would be very displeased with me because it would be a disaster. So we hire experts to do the things that we're incapable of doing adequately ourselves. So tip, know what you know, be even more aware of what you don't know, and be willing to seek professionals when you're in over your head. The next question I have is on legal compliance. What's important to know about legal compliance? It's a very broad question, but often what we see in contracts is some obligations, sometimes very simply phrased, sometimes very fleshed out, that says that one or both parties has to comply with the law or with applicable law, meaning laws that govern the relationship. In some industries, those laws are extremely complex and they're very specific acts or statutes that govern the types of activities being engaged in. For example, if something involves environmental waste, I can assure you that in the United States, there are significant federal regulations and often state regulations that govern that behavior. If you're using internet marketing, you may run into spamming type laws and regulations. So legal compliance is important. And sometimes it's very subtle in the contract because it will just say each party shall comply with all applicable laws and regulations, basically. That's a very broad obligation. And if you don't know what your what laws apply, you probably should do some research, maybe hire an expert in legal compliance. But it's important to understand what your obligations are, what you can and can't do, and make sure that you are not violating the law, because not only if you violate the law are you able to be potentially prosecuted by a government authority for violating that statute, but now that it's in the contract, you have a second legal problem, which is that may constitute a breach of the contract. And when there's a breach of a contract, as I mentioned at the top, you can often enforce that in court. Generally speaking, you enforce that in court. So legal compliance, look at it carefully, be aware, seek advice when you're unsure. The next question is a really good one as well, and it's what happens if the contract is breached? I spent many years, 20 plus years litigating contract disputes, as well as drafting and negotiating contracts. And when a contract is breached, that takes us again back to the top and the notion of what contract law is. Remember, I said that courts are willing to enforce the private relationships of private parties when they enter into a formal agreement. Now, I'm not going into all the details of what constitute a formal agreement, but I'll even suggest that at times oral contracts, non-written contracts can be binding. And so it's an excellent question, because this is where the rubber hits the road. What happens when there's a breach? The whole reason you have a contract is to be able to enforce it in the event of breach. I'm going to interject here for a moment. We have decided as a world, because this is probably true in just about every legal jurisdiction on the planet, that when somebody breaches a contract, the primary remedy is money. That's what compensates for a breach. So if I paint your house fluorescent green and you intended me to paint it white, you're probably going to be upset. I've breached the contract by painting it the wrong color. And what do you get in compensation? Generally speaking, the law doesn't impose behavior on a party, doesn't say I have to repaint it, or I have to unpaint it, whatever that means. But it is about giving you monetary compensation so that, for example, you could hire a better, hopefully better painter to get it done the right way, so that you can undo the effects of what I did. That ties into the limitation of liability clauses we talked about above, how far those damages extend. But when you hear the term damages in the law, and what comes from a breach of contract like this question is asking, you're usually talking about monetary damages, money, cash, as a proxy, a replacement for some other way of remedying the wrong. So if I did paint with toxic paint and I did indemnify you against claims from neighbors and their dog did get very sick and there's a vet bill and I do have to pay it, I'm obligated to pay the vet bill, not to cure the dog or replace the dog necessarily, right? There are situations where a court can force behavior, like force someone to do something or prevent them from doing something, such as through an injunction or a temporary restraining order or something like that. But generally, the law does not impose and doesn't favor those types of arrangements where somebody's being forced to do something. They prefer in civil disputes to have money replace other forms of recompense. So getting back to the question, what happens if the contract is breached? the first thing I do when there's a breached contract is I look at the contract itself. And by the way, I don't care if I negotiate that contract. I don't care about the negotiations, all the discussions. When I'm looking at that contract, I'm looking at the four corners of the contract. What does the contract actually say? I don't burden myself with what I understood it to mean, because generally speaking, courts do not look outside the four corners of the contract unless there's a problem with it. And so your rights and obligations are determined largely based on what's written down in black and white and what that means. So the first thing I do when there's a potential breach is I review the contract. I discuss the facts, the background facts, the information around the contract, who is doing what, and what the understanding of my client was. And then I start looking at clauses, scope of work, perhaps the termination clauses, what happens in the event that there's a termination of the contract, the termination rights of the parties that might be implicated. I look at the exact provision that was breached. I might determine whether it's what we call a material breach or a default, or just an incidental breach. You know, let's say that I painted your house, but failed to paint 1 square inch in a corner. I just somehow missed a square inch. You can claim it's a breach of the contract. You paid me and I didn't do the full job. But I would not consider that a material breach necessarily. What I would try to do in that situation, if that's the breach, I would say, look, let's finish the paint job. Let's just get you over there, paint that last square inch and be done. So another thing to look at in a contract, and this can be very powerful in some jurisdictions and less so in others, is what we call liquidated damages. And that is a way of sort of end running the dispute process. So whether it's litigation through courts or arbitration or mediation or some other mechanism of dispute resolution. And by the way, I had a client once suggest duking it out with the other party. Having a boxing match might be a good way to resolve the dispute. So there might be non-traditional things that people come up with. Not saying I advocate that, but it was suggested. We didn't end up having a fight. But those things, typically the dispute resolution process takes time and money. So what some contracts do is try to eliminate that need in certain situations. And one way that's done is through a liquidated damages provision. That is a predetermined, pre-agreed upon amount for a particular type of breach. So for example, I'm having the wedding, it's May, I want this contract done by May 1st. The wedding's on May 7th. Please paint the house before the wedding. So going back to my hypothetical earlier, but we might say every day after the 1st of May that the house is not fully painted, I'm going to be penalized $1,000. That gives you the ability to recover that amount from me or withhold it from what you owe me without going to court over it. And also to motivate me to finish the house in a timely manner. So liquidated damages, again, just to recap, are a way of calculating damages, harm, in advance of a breach, in advance of the harm being incurred. So a monetary value on an anticipated or potential breach. So I would, getting back to the question, what happens if the contract is breached? I would look and see if there are any liquidated damages clauses, which some courts in some jurisdictions interpret very strictly. And so, in other words, would enforce very willingly and only in the most extreme situation, maybe try to not enforce it. So liquidated damages are definitely a powerful deterrent. Other things to look for in the contract is what law governs the dispute. Is it a law of a jurisdiction I'm familiar with? Look at the implications of that law being applied. What courts would be would it be litigated in, or what arbitration procedures, and try to understand how to pursue the enforcement of the contract. Often what happens then is we make a strategic decision on how to proceed if there's a clear breach, say, by the other party. It might involve a demand letter where, you know, a formal written demand from an attorney is sent. It may involve other things, you know, reaching out for, you know, mediation if that's required. If somebody's has reached out to me or to my client with a demand letter and they want to begin the process, I would first evaluate my client's risks and position, and if my client is at fault, try to negotiate a fair conclusion. If we feel like the other party's at fault, to resist it and present defenses. Or if both parties share some fault, try to resolve it amicably before going to courts. But again, the courts is where the rubber meets the road. That's where a contract is enforced, and that is there are two big outcomes of a contract. All the parties perform fully as envisioned, and everybody's happy, and they move on. Or it ends up in dispute, and then it's enforced in court, and that's where you see the strength or weakness of your contract, and you see the power of the clauses that we discussed previously, and how that they're enforced or pursued, and how we allocate the risk between the parties. So that's when you really care. You care mostly about the contracts that are in dispute rather than the ones that go smoothly. Contracts are there really as insurance against things going awry, and to keep people on track. And I say kudos, congratulations to anybody where you had a smooth sailing and didn't have any dispute. The contract may have been part and parcel of that. It is time to wrap up. I appreciate everyone's participation and attendance. It's been a pleasure to answer a few of these questions. This is general advice only, not specific legal advice for your needs, but hopefully has helped you understand how to navigate commercial contracts a little bit better, what things to look out for, and the value of getting good advice. If you have further questions or would like a deeper dive, we're going to be doing a live question and answer session where you can just ask any questions and I'll answer those. And we'll have other content available as well. Thanks again for joining, and I look forward to the opportunity to helping you simplify your contracts. Thank you all.